Good morning, I'm Gary DeWaal, and this is Bridging the Week for November 14th to 18th, and today is November 21st, 2016. The federal court hearing the Commodity Futures Trading Commission's enforcement action against alleged flash crash spoofer Navinda Sarao accepted a settlement offer proposed 2 weeks ago, while a three-judge panel of the Federal Court of Appeals appeared to be sympathetic to Michael Coscia when it heard arguments to overturn his November 2015 conviction for spoofing. Separately, an international bank and an affiliate were sanctioned almost $264 million by the Department of Justice, Board of Governors of the Federal Reserve System, and the Securities and Exchange Commission for hiring relatives and friends of many government officials in Asia, including in China, in the expectation of being awarded investment banking business from such government officials. This week is Thanksgiving in the United States, so I get home and entertain my guests and cook my turkey. Let's get started. The U.S. federal court handling the civil case brought by the Commodity Futures Trading Commission against Navinda Sarao for alleged spoofing from April 2010 through April 2015 accepted the settlement agreement jointly submitted by the CFTC and Mr. Sarao 2 weeks ago. Under the terms of this agreement, Mr. Sarao will pay a fine of over $25.74 million, disgorge profits of over $12.87 million, and be permanently barred from trading on CFTC supervised markets, among other sanctions. The CFTC filed its complaint against Mr. Sarao in April 2015, charging him and his trading company with engaging in spoofing and layering activity involving E-mini S&P futures contracts traded on the Chicago Mercantile Exchange during the relevant time that netted him profits in excess of $40 million. Mr. Sarao was specifically accused of having engaged in illicit trading that contributed to the May 6, 2010 flash crash. 2 weeks ago, Mr. Sarao also pleaded guilty to criminal charges brought by the Department of Justice related to the same essential conduct. He awaits sentencing in connection with this matter. Separately, three judges of the U.S. Court of Appeals for the Seventh Circuit heard oral arguments November 10th related to Michael Coscia's efforts to set aside his November 2015 criminal conviction on 6 counts of commodities fraud and 6 counts of spoofing in connection with his trading activities on CME Group exchanges and ICE Futures Europe from August through October 2011. During his presentation, Mr. Coscia's counsel principally argued that the provision of law prohibiting spoofing, under which Mr. Coscia was prosecuted, had not given him adequate notice of what trading activity was precisely prohibited. This was because the relevant provision of law did not define spoofing, and prior to the time of Mr. Coscia's alleged wrongful conduct, the CFTC provided no guidance regarding what constituted prohibited spoofing. The relevant provision of the Dodd-Frank Wall Street Reform and Consumer Protection Act, under which Mr. Coscia was prosecuted, first became effective in July 2011, just a short time prior to Mr. Coscia's alleged wrongful conduct. The judges hearing the case asked questions of both counsel for Mr. Coscia and the United States to clarify differences between contingent orders and orders that constituted spoofing, and to assess whether spoofing solely represented an evolution of market practices to address high-speed algorithmic trading. J.P. Morgan Chase agreed to settle charges brought by the Securities and Exchange Commission and the Board of Governors of the Federal Reserve System that between 2006 and 2013 it provided jobs and internships to relatives and friends of Asia-based government officials, including officials in China, to retain or obtain investment banking business. The SEC said this conduct violated a federal law known as the Federal Corrupt Practices Act. According to the SEC, during this time, J.P. Morgan Securities Asia Pacific Limited, an affiliate, established and maintained a referral hiring program internally termed the Sons and Daughters Program. Within this program, said the SEC, J.P. Morgan APAC processed the referral of relatives and friends of senior executives of clients and prospective clients and senior government officials, including senior officials of many state-owned enterprises in China. Candidates in this program were not subject to J.P. Morgan's ordinary rigorous competitive vetting process, but an alternative non-competitive hiring scheme. To resolve these charges, J.P. Morgan agreed to pay more than $130 million in disgorgement to the SEC and $61.9 million as a fine to the Federal Reserve. In a related matter, JP Morgan APAC agreed to pay a penalty of $72 million to the U.S. Department of Justice and enter into a non-prosecution agreement in connection with the same essential activity. The SEC noted that it did not impose a fine on JP Morgan because of JP Morgan APAC's agreement to pay a fine to the Department of Justice. CME Group proposed to amend its market guidance related to wash trades to make clear that its self-match prevention functionality does not prevent self-matches on the opening of a market where the orders were entered into the pre-open state on Globex. In its proposed revised guidance, CME Group also made clear that it would consider it a violation of its prohibition against wash trading for a person to enter orders during a pre-open state that it knew or should have known would match. An example of such orders would be a buy order placed above the price of a resting sell order or a sell order placed below the price of a resting buy order. In addition, CME Group noted that indirect wash trades as well as direct wash trades are not permitted. CME posited as an example that a prohibited indirect wash trade would include a situation where three traders signed up for an incentive or rebate program and, with or without prearrangement, executed a series of transactions in close time proximity, buying and selling similar quantities against each other, and at the conclusion of trading, the traders had no change in position. Absent CFTC objection, CME proposed revised guidance in the form of a market regulation advisory notice will be effective December 1st. And finally, Atlas Commodities LLC, a Commodity Futures Trading Commission registered introducing broker, agreed to pay a fine of $65,000 to resolve a disciplinary action brought by ICE Futures US that it failed to properly handle block trades for its customers. According to IFIS, Atlas may have unspecified quote-unquote multiple occasions misreported to it the correct execution time of block trades, reported such trades beyond the 15-minute required reporting period, and failed to have adequate procedures to ensure correct trade deals were reported to it. IFIS said that Atlas might also have not recorded and maintained oral records related to the execution of a consummated block trade as required for non-member IBs, or introducing brokers. Well, that's it for this week's edition of Bridging the Week. As always, there is more information there's more information in each article and more article on the article version of Bridging the Week on the website. Check it out. I'm Gary DeWaal. Have a great 2 weeks, as Bridging the Week will not publish next week. And until the next edition of Bridging the Week, ciao.